Good afternoon, everyone, and welcome to today's webinar. My name is, hold on one second. Here we go. All right, surviving the stand, how to testify in a child sexual abuse case. My name is William Moore, and I'm with OJJDP's INTAC. And before we get started, I wanted to go over a few technical pieces of today's webinar to keep in mind while we go through our presentation. Please note that this webinar is being recorded and will be available on our INTAC YouTube channel. You can visit our INTAC YouTube channel where you can view past archived webinars as well. If you'd like to get access to the transcript or any supporting materials, you may do so by contacting the OJJDP TTA Help Desk at the information on this slide. For those wishing to download a copy of the PowerPoint handouts that are related to today's webinar, you may do so by locating the handouts pod that is directly next to the chat pod here. Simply click on the name of the file and click the download button. During today's webinar, our presenter will be addressing your questions. To get your question addressed, you may simply type it in the chat pod, and we will address it during our Q&A portion of today's presentation. For those who are attending, you will receive, and logged in and signed into Adobe, you will receive a certificate of attendance. This certificate of attendance will be provided through an automated email through Adobe Connect. However, if you're viewing in a group and you would like for individuals who are viewing with you to receive a certificate, then please go to the handouts pod and download the group validation form, complete it, and send it to OJJDP TTA at usdoj.gov. That's where we'll be able to verify that the attendees were indeed there, and we'll be able to provide them with a certificate as well. Speaking of our last activity before we get started, I'd like for folks to indicate if you are attending in a group, meaning it's yourself and other people with you, please indicate the number of additional people with you. So for example, right now it's me and my plant, that's plus one that I'll put in there because I have one additional person that's in the room with me viewing today's webinar. So if you could please go into the chat and type the number of additional people in the room with you today, not including yourself. That being said, I'll turn over the webcam and the presentation to our presenter for today, Robert Peters. Robert, feel free to take it away. Thank you.
Thank you, William. Well, it's great to be here with you all today. Just in watching the polls, great to have so many different disciplines represented. I appreciate all you do. These are difficult times. These are important times. And hopefully what we'll touch on today will be of relevance to all of you. We definitely will have a bit of an emphasis on forensic interviewing and just in general interview practices. Let's dive on in. Definitely reach out to me at robert@zeroabuseproject.org. Again, Zero Abuse Project provides training and technical assistance. Happy to do anything we can for you, not just in the training field, but also in technical assistance, working with cases, developing memorandum, developing pretrial motions. We're here. It's your taxpayer dollars at work, and we are grateful to the Office of Juvenile Justice and Delinquency Prevention for sponsoring these trainings. A few quick disclaimers. None of this is intended to constitute legal advice. I am an attorney, but I'm in West Virginia, and just looking at our attendee list, you all are from everywhere, not just across the nation, but globally. So really excited by the international presence we have here today. I am simply not competent in the law in all of your jurisdictions, so I'll be leaning on some of my experience and expertise, but certainly always contact your local prosecutor, local attorney in your jurisdiction as your rules may vary. Please don't commit reversible error simply based on something I said. And certainly credit to Victor B., Rita Farrell, the entire Zero Abuse Project team members for the significant content and research contributions that they bring to these presentations. Bit of an overview for today. We're going to talk about preparing to testify. Hopefully this will help prosecutors in terms of areas to cover with your witnesses, and hopefully will also help the rest of you in just a couple tips in getting your cases ready for court. We'll talk about direct examination considerations, and again, we're going to focus a bit on forensic interviewers, and then some cross-examination considerations. What are some of the tactics that attorneys tend to use? We're going to discuss general testimony tips, common traps to avoid, and I'm going to attempt to leave a good bit of room at the end. We received over 100 questions in advance of the presentation, which is fantastic. I did policy debate when I was in college, so I'm capable of auctioneering speed, but that's probably not all that useful. So we'll pick a couple of those, spend some time on those, and definitely weigh in with your questions throughout, and we'll get to as many as we can. But afterwards, my commitment is, assuming I can hunt down an email address for you, I do want to follow up with everyone who asks a question and make sure that we get some resources and information to you. Thank you again in advance for your interactivity. So preparing to testify. Court preparation doesn't begin the week before court. It certainly doesn't begin the day before court. It begins the day the case is reported. And so a lot of how you handle the case certainly has great implications on how your testimony is going to go. So we need to be working to improve our craft. We need to be working, to continue furthering our education and skill set, to understand the research that underlies forensic interviews. Of course, we want to review carefully everything that was done in the case, anything our organization covered, anything our organization wrote. If we're on the social services side, certainly the services offered, the outcomes, the reasonable efforts, the findings, all that good stuff we'll want to be reviewing. Remember, of course, the civil cases have application on the criminal side and vice versa, so we definitely want to be familiar to the extent permissible by law to make sure that all of that is covered. We certainly want to be reviewing the statements of parties that we have access to, especially those of you who are investigators of social services. And I know some of these are pretty basic tips, but hopefully this is something that's broadly applicable to all of you regardless of skill set. Of course, we want to watch the forensic interview if we have access to it several times close to trial. We want to be familiarized with literature and updates in the field, especially those that are unique to the case. If you have a case where, say, a child has an empowering type narrative, say a child says, the abuse occurred, and then I shot him in the face, or then I stabbed him, or things like that. Things that we know didn't happen, but we know there are reasons why a child might make those statements in attempting to seize control of the narrative and seize power back. So trying to research topics in those types of fields are good things to definitely seize on. And I see some discussion of an inability to hear me, so I will talk a little bit louder. In our report drafting, certainly report drafting is relevant to how we do on the stand. We want to be objective in our report drafting. We want to make sure that there's not any clear bias that's coming forward even as we write these reports, whether that be on the CPS side or the investigative side. We want to be descriptive of what occurred, so appropriately convey the severity of what occurred, but we also want to be concise, and we certainly want to avoid any sort of impeachment material for bias. One thing that I thought was helpful in terms of clarifying just facts and circumstances of the case is create timelines. Certainly if you're a prosecutor, creating those visual timelines are really helpful for the jury. But even if you're not a prosecutor, just to clear out the facts and circumstances of the case, it's very helpful. Just to clarify what occurred and when it occurred. And of course, practicing is helpful as well. And of course, social media. Those of you who are investigators, we certainly know that social media is a fantastic gift to investigators. Many times we find some fascinating things in the digital realm, but that can go against us as well. So we certainly want to watch our social media statements generally to avoid statements that might be biased or some things we might be attacked for. Certainly we don't want to be referencing a specific case on social media, but we want to watch that especially in lead up to a trial. I was watching a mock trial in Atlanta at the National Law Enforcement Conference on child exploitation, and Justin Fitzsimmons was the presenter who had organized this mock trial, and so they put the witness on the stand in this mock trial, and in advance they found where that witness had posted statements along the lines of, it'd be better, the scripture verse that it would be better for a millstone to be, thrown around the neck of someone that could be drowned in the ocean than if they would offend a child. Now, regardless of how you feel about that statement, that's something that they were able to then get some mileage off of in terms of showing bias in the trial itself. So that's certainly something to be aware of. And yeah, so there's a lot more we could say there. But long story short, definitely want to be watching our social media presence. All right, reviewing the case with prosecutors before trial, preparing for direct examinations. I've heard from investigators and from forensic interviews across the nation this standard complaint about being thrown in a courtroom without preparing with a prosecutor. And in fact, several of your questions were towards that, were on that. Many of your questions were oriented towards that. How do I meet with a prosecutor? So for the prosecutors in the room, it's certainly important to make sure that we're meeting with witnesses in advance of trial. And I know that many prosecutors aren't meeting with kids prior to trial. And so those of you who work with kids, whether you're victim advocates or whether your forensic interviewers who have continuing contact with children, it's a good thing to highlight that with your prosecutor about the importance of testimony and of children developing a rapport with the prosecutor. So, for example, one of you had asked in questions that you submitted for this presentation, why do prosecutors avoid speaking to victims, and how can this hinder a case? And again, I've heard several stories where a prosecutor would simply introduce themselves to a child when the child is on the stand. Well, in my view, that's frankly malpractice. I mean, imagine if we did that in a civil case, and you introduce yourself to the star witness in a civil case as you put them on the stand. I would hope that isn't happening, and it certainly shouldn't happen in the criminal case as well. If you do that, there's no way that the child has any reason to trust you in the courtroom. And overall, there's no way that you're getting the best information from the child if you do that. And also, there's no way that you're maximizing the child's chance at justice if you don't have those taking that time to build rapport prior to trial. So I would recommend certainly having at least 3 meetings. If you're a prosecutor, having at least 3 meetings with a child victim prior to trial. And at the first meeting, I wouldn't even go to discuss the merits of the case or the facts of the case. My suggestion would be to just learn what the child's likes and dislikes are, and just learn about them. What are their favorite subjects at school? What are they? How's home life? Things like that. So yeah, I think that'd be important, and I've seen what happens when that isn't done. And certainly, so to the question of, there was also a question of how can victim advocates encourage prosecutors to build rapport with victims prior to trial? Well, we can talk about the importance of reducing trauma. Certainly we know if we can support that child, if we know if we can reduce a lot of their anxiety in advance of court, that's important. That's a really, that's a gift that we can give. You think about all the uncertainty. That uncertainty is definitely a stressor. Not knowing what's going to happen. That gives all of us anxiety, right? That gives all of us anxiety. And so certainly how much more so with the child who has to testify in front of their perpetrator. And also we can focus on the outcome. A child who spent time with the prosecutor in advance of trial and who's really developed a rapport with the prosecutor, that's a child who has a greater likelihood of being able to really clearly articulate what occurred on the stand. I think of a case that I had where a child was able to go through numerous photos and was able to point out with specificity where abuse occurred, and was able to really increase her credibility over the course of trial. because she was able to spend time in rapport and understand the process and develop rapport with the prosecutor. So I would say focusing on the trauma piece is important. Prosecutors certainly want to act in a way that is in the best interest of children, but also focusing on the outcome side of it and understanding just the value of that discussion and of that preparation. Another thing, obviously, to discuss with prosecutors in advance of trial is admissibility. If you are, if the prosecutor is seeking to introduce any sort of exhibit through you, that's information that you need to know and be on the same page. How does the prosecutor plan to do that? If you're a forensic interviewer, is the CAC interview going to be introduced through you? Is it going to be on a CD? Is it going to be still photos of different relevant pieces, perhaps, of the forensic interview? Is it going to be on a jump drive? Is it going to be on a digital file, on some sort of electronic device? Have you reviewed those items? Have you actually looked at those particular devices? And so can you testify that the interview is actually on those based on your direct knowledge? You know what type of
years ago we talked to Tom Moore then in Indianapolis, the offensive coordinator. You got a busted play here, and then Sanchez gets hit. The ball is loose, and it's alive.
I have never seen this before in my life. Watch this. Vince Wilfork is going to throw Brandon Moore back into his quarterback. He's going to fumble the football. This is what Reggie White used to do to people. Forklift them and just lift them off the ground. Mark Sanchez not expecting it, and it was the backside of Brandon Moore that knocked the ball out.
What is it, hey? All right, so don't be like the New York Jets and let evil win. And yes, I guess I'm using the terms evil and the New England Patriots interchangeably. That's not a here nor there. All right, so preparing for direct examination. Let's walk through that a little bit. Asking the prosecutor, what's my role as a witness? Where do I fit into the big picture? And how are you looking to deploy me in this case? Many of you are certainly capable of being qualified as expert witnesses. Police officers can certainly be qualified as expert witnesses in certain fields. Forensic interviewers can certainly be qualified as expert witnesses. And so if that's an option, certainly being on the same page as your prosecutor on what field you're going to be qualified in and where they see you fitting into the strategic picture of trial. Maybe you provide therapy, maybe you did a diagnostic assessment, maybe you have some unique publication or certification. Even if you don't have some specialized certification or degree, your experience is really phenomenal, and particularly compared to many defense experts. So let's focus on the context of forensic interviewing for a second. Defense experts in forensic interviewing, they may very well have impressive degrees, but odds are they haven't actually done an interview of a single child. And they certainly haven't done it hundreds of times, as many of you have on the call. And so knowing the precise number of times that you've conducted a forensic interview is certainly something that's helpful in order to establish your expertise in forensic interviewing protocols. And those are all important things to focus on. And so the question might be raised, why would we spend a good bit of time on discussing forensic interviewing protocols? What's the value of calling forensic interviewers as witnesses? Well, certainly getting the forensic interview admitted into evidence is helpful and it's important, and it is possible in many jurisdictions. Sometimes we arbitrarily limit ourselves and don't view that as a possibility, but oftentimes it is an option. And the other thing I would say is when we're discussing the forensic interviewing protocol, what we're showing is the value of that evidence in. Certainly we want to be reviewing and updating the resume, especially if we're testifying as an expert witness. And remember, you can be qualified as an expert based on training as well as experience. And for that reason, we emphasize the forensic interviews and things of that nature. We certainly want to know the limits of expert testimony and review those with the prosecutor. So, for example, if you're appropriately qualified, in West Virginia, some professionals can opine that a child exhibits symptoms or behaviors that are consistent with behaviors of a sexually abused child. In other jurisdictions, that's completely prohibited and would be reversible error, in fact. So again, we have to be communicating with the prosecutor on that front. In general, it's a very good idea to listen to your prosecutor. And there's a variety of fun stories I could tell there that we will skip over just in the interest of time. If an attorney asks, and this is for those of you that are a little less experienced, if an attorney asks you if you met with the prosecutor before trial, don't be nervous about it. I mean, the goal of a defense attorney oftentimes is just to throw you off kilter a little bit or to unnerve you on the stand. Don't be nervous. There's nothing improper about meeting with the prosecutor prior to trial. I remember one case that I had. The defense attorney asked a young child victim if she had met with me prior to trial, and she called me Mr. Robert. And so he asked the child, did you meet with Mr. Robert before trial? And the child says yes. And then he's, of course, all excited. And did you talk to Mr. Robert about what you were supposed to say today? Yes. Did Mr. Robert tell you what to say today? Yes. And you can tell the attorney's eyes are lighting up. He's maybe salivating and sharpening his knives a little bit. And then he says, I want you to tell the jury today what Mr. Roberts told you to say. And the child looks at him and says, the truth, right? Just tell the truth. We're not exaggerating, and just tell the truth. The truth shall set you free. Let's talk a little bit about the purposes of direct examination. So to some extent, they're supporting the statements of the child. Certainly, if there's corroborative pieces, that's relevant. Highlighting the corroboration that we found over the course of investigations. Now, that's not so much going to be the role of a forensic interview. Certainly, that's more on the law enforcement side of things. But it's important to remember that the forensic interview is not the end of an investigation. The forensic interview is the beginning of an investigation. And so what we need to do as prosecutors, as investigators, is look at every single sentence of that forensic interview, and we need to be corroborating or refuting every single piece of it. And we can't be putting it all on the child's shoulders. When we just throw the child on the stand, especially if we're not preparing the child for trial testimony, we're really doing a disservice to that child. We're not maximizing the chances of justice. It's unfair of us as child protection professionals to put that burden squarely on the child's shoulders. It really needs to be a team effort, and we can reduce the burden on the child by engaging in thorough investigations and prosecutions to highlight corroboration. Certainly a purpose of direct examination is to educate the jury on the dynamics of child abuse and on child development. And what we're doing there to some extent is setting up the cross of a defense expert. As I said earlier about explaining forensic interviewing protocols, we're showing the integrity of evidence collection. It's not bolstering. Sometimes it's misconceived as bolstering. When we're just showing the standard chain of custody, for example, when we're introducing DNA evidence through a law enforcement officer, typically we don't get an objection from a defense attorney that says, oh, that's bolstering, Your Honor. He's talking about we're talking about what a great job that the investigator did. No, we're showing the integrity of evidence collection. That's important for us as we're attempting to meet our very high burden of proof. And how much more important is that when it comes to the child statements, which, as we know, are so integral in child sex abuse cases, and they often are the most powerful piece of evidence in our arsenal. So it's not bolstering to discuss interview protocols, though it may sometimes argue that it is. When it comes to the purposes of the direct, we're not hoping at any point that we just won't address something that we're nervous about and the defense attorney will skip over it. I have a photo of Antonio Banderas there, and it's not just a subliminal attempt to get great evaluations from you all after that. If any of you have seen the movie Desperado with Antonio Banderas, there's a scene early on in the movie, maybe the first scene, where Antonio Banderas walks into a bar south of the border, and he has a guitar case, and he opens up the guitar case, and it's full of all these firearms. A large gunfight ensues. Of course, he takes out scores and scores of bad guys, and then he's down to one opponent, and Antonio and the opponent keep diving for different guns that are scattered around this bar, and they keep pointing them and firing them at each other, but it's just a click. All these guns they keep jumping for and pointing at each other are unloaded. That is an example of a successful direct examination. There's nothing the defense attorney can do on cross-examination that you haven't already addressed and unloaded on direct examination. Sometimes I've seen this tactical mistake that child protection professionals make where they hide something that they're nervous about in hopes that the defense attorney won't notice. First of all, defense attorneys actually are pretty good, even ones that might not seem as competent. Defense attorneys are pretty good at finding the holes in these cases, and furthermore, we need to be honest. We need to be honest. The truth is the truth. Warts and all, we need to be honest and address it openly on direct examination. That has a tactical benefit in that we can frame it in such a way that's more persuasive, not in the misleading way that a defense attorney might construe it. So again, before trial, the importance of training, as we discussed earlier. Certainly we want to be engaging in intensive training. We know from research that experiential training is the best training. When you're actually engaged and doing it, that is certainly helpful. Zero Abuse Project has a great course called Forensic Interviewer at Trial, where teams of prosecutors and forensic interviewers do a direct examination. The prosecutor does the direct, then myself or Victor Beeth does a cross-examination, and we, channel our most obnoxious selves to try to put together a really brutal cross-examination. And we've heard feedback from those courses where that really enhances the confidence level of attendees. They feel more equipped in their courtrooms because they went through that experiential training process. Of course, experience is not a substitute for training. And so certainly we need to be engaging in training even if we do have significant experience. The questions for trial preparation. This is another one of the questions that was raised by some of you in submitting questions for this course. This is specific to forensic interviewing, though it has some applicability elsewhere. And whether you're a forensic interviewer or investigator or any other witness, ask yourself the question, what concerns do you have? What makes you uncomfortable with your case, whether that be watching the forensic interview, if you're a forensic interviewer, whether it's some steps you took or perhaps didn't take in the investigation, or perhaps as a therapist, what makes you nervous about what you might be probed on the stand. And have those conversations with your prosecutor, because whatever makes you uncomfortable is probably where we need to be spending our time. What mistakes did you make? And just the importance of owning those, but talking about those in a persuasive way. What question or topics are you afraid to address on the stand? And then we need to be talking to the prosecutor about what the defense attorney's like. What are their standard cross-examination tactics? And we'll get into some of those in just a moment. What attacks do we anticipate on the forensic interview? You might be, if you're a forensic interviewer, a better source of information on that. The prosecutor, you might be anticipating attacks that the prosecutor hasn't thought of due to your familiarity with the forensic interviewing protocol. Is there an expert attacking the forensic interview? That's critical because your direct examination sets up the prosecutor's cross-examination of the expert. Those two pieces work together very closely, and so you have to know what the expert is attacking, so that's something that we can address on direct examination. Of course, we want to make sure our CV is relevant and up to date. As we discussed earlier, how many interviews or investigations have been done. Certainly we want to be engaging in the peer review process, those of you who are forensic interviews, and just improving your craft. And of course, any trainings conducted, very important to keep tabs on all those things. We already talked about the importance of why we should articulate the interview protocol, but being able to do that, explain how it is supported by research. All forensic interviewing protocols in the United States are supported by research. They all provide structure and guidelines, and these forensic interviewing protocols aren't rivals. Zero Abuse Project trains and teaches child first in several states across the nation. There are other wonderful protocols out there, NICHD, the National Children's Advocacy Center, and others. They're all based by research. They're all based by science. They are all legally and scientifically defensible. For the prosecutors who are in this training, here's a great way to build your direct examination of forensic interviewers. Look at the DOJ guidelines that break down the components of what should be in a direct examination. Likewise, the ABSAC guidelines. What are forensic interviewing guidelines? What are the guidelines on anatomical laws? Look through those best practices, and then you can build a direct examination around all those components that are in the forensic interview in your immediate case, and show what a fantastic job it's done, certainly, but impliedly to the jury, but also showing the integrity of that evidence collection process and how this was done in a way that truly obtained the child's words and the child's perspective and was free of misleading, suggestive, and coercive influences. And you see there the resource, Child Forensic Interviewing Best Practices by OJJDP. You can actually access that if you look down in the window handout. You can go ahead and download that and use that in your cases. Use it if you're a prosecutor. Pass on to your prosecutor, your CAC, if you're another member of the MDT. Again, this was created by all the major national forensic interviewing courses. It's endorsed by the Department of Justice, and it's a great resource for you that you have available. So the question I often get asked is, look, I tried to contact the prosecutor repeatedly before trial. I couldn't get him to pick up. How can I really proceed? Well, after trial, it's nothing else. Obviously, we want to be meeting before trial so we understand how we fit in that big picture. If all else fails, having a conversation after trial and approaching it not as, in this aggressive way that calls them out for not doing what they should have done, but asking, look, how was I effective? How was I ineffective in court? These are the pieces that I really struggled with. How should I handle this next time? Meeting with the prosecutor, regardless of your role, to debrief after trial and how you can improve next time. That can certainly be helpful. Meeting with the multidisciplinary team and debriefing what occurred, regardless of outcome, what additional services are required for this child and this family, and were there things and issues, topics that came up that might impact future investigations. All right, so we talked a bit about direct at length. Let's focus a little bit on cross-examinations. So we want to be thinking, what are some of the key points that we can emphasize on cross-examination? It's sort of the inverse of direct examination. You're not going to be able to really script, for lack of a better word, your cross-examination like you can a direct examination. But what are the key points as you think about those pieces of the case that make you nervous, the pieces that you're afraid to address? What are your key points, key 1 to 3 points that you would use to really respond to hard questions and attacks on cross? And so for every one of those weaknesses, you really want at least one, certainly, but at least 3 pieces that you can counter with, and you want to really spend some time preparing on those. Certainly cross-examinations vary from attorney to attorney. My cross-examination is different than Victor Veith's cross-examination, my supervisor at Zero Abuse Project, and certainly defense attorneys' tactics vary greatly from either of ours. So that's where that communication with the prosecutor becomes helpful in advance. What does this defense attorney tend to do? Is he the type of defense attorney who opens with a series of concessions? He asks you a bunch of questions that sort of lull you into a false sense of complacency, just really easy questions. So you start to get comfortable on the stand. You say yes, 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 yes in response to a bunch of uncontested type information, which you should. But then you get really comfortable, and you don't see the trap that he's very slowly and artfully weaving for you until you're in it, and there's no way out of it. Or is this the type of defense attorney who's just going to lead with a haymaker? He's going to knock you as hard as he can as soon as you sit down on the stand, just to try to rattle you, to keep you from developing any type of comfort level. That's a good thing to know, so you're ready for it. Yeah, as Mike Tyson said, everyone has a plan until you get punched in the mouth. So is this the type of defense attorney who's going to try to unnerve you and then keep you off balance across the cross-examination? What type of cross-examinations might you expect? Well, there might be attacks on credibility. There certainly any sort of background expertise, especially if you're testifying as an expert witness, so you're probably going to get credibility attacks regardless. And so this goes to the importance of not exaggerating your credentials or your expertise on direct, right? By the same token, you don't want to sell them short either. If you conducted 872 forensic interviews, you should probably say that you conducted 872 interviews. Knowing that specific number can certainly increase your credibility. Certainly, you might see attacks on bias. In terms of your work with the prosecution, if you're an investigator, just in general working with a multidisciplinary team, if you're a forensic interviewer. One thing that's sort of interesting, there's an article that just came out in the ABSAC Advisor, and I'm sure all of you have seen to some extent attacks on forensic interviewing perhaps, or investigators generally for bias and things like that, bias against defendants. And it turns out, this article is specific to forensic interviewers, but it turns out that there in fact may be some bias that forensic interviewers, or rather the field of forensic interviewing has, but it's not towards the child. Actually, this study shows that there's a bias towards protecting adults throughout the forensic interviewing process. We try very, very hard to avoid any sort of infringement on the rights of adults. We're very, very focused on avoiding any sort of false positives, right? Any sort of false allegations, as we should, but we don't have an equivalent focus on those false negatives. Think of all the checks in our system that are designed to counter against, say, false allegations. And now think about what are the recourses for false negatives where a child denies abuse but abuse occurs. What are the fail-safes on that side of it? Well, they don't really exist. So perhaps there is bias, but generally it's not bias in favor of the child. Lawrence Braunstein's a trainer. Saw several times in Dallas, very talented speaker. He is a defense attorney who talks a little bit about some tips and tricks that defense attorneys use in child abuse cases. And he summarizes cross-examination in this way. Do you know what you were supposed to do, and did you do it? So those are key questions to consider as you prepare for cross-examination. Do you know what you were supposed to do in this case, and did you do it? And being honest in that process. Certainly impeachment is something we're concerned about. If there's any sort of contradictions, oftentimes we know that defense attorneys can engage in smoke and mirrors attempting to paint contradictions where there is none. So that's something we might get crossed on. We often see that certainly with children when children are cross-examined. And you think about the standards that we expect of children are actually quite a bit higher than the standards we expect of adults. Let's just think to use an example in many of our lives. If you were asked by an individual to describe what happened on your wedding day, and then you're asked by another person what happened on your wedding day, but the question is phrased in such a way that you're focusing more on what happened at the reception, is this a horrible contradiction that proves you're a raving liar? No, it doesn't. That's not a contradiction, but it's just the questions were different. The focus of the conversation is different. And so naturally there's going to be things that on the surface might appear to be contradictions, but they're really not. And we know that those are things that defense attorneys do sometimes seize on. Obviously, if there was any untruthfulness, that is fair game for impeachment. Certainly if you claim knowledge you don't have, that's a huge issue. We know that perception and memory, of course, have a great deal of focus. And, of course, there's persistent claims of suggestibility with children. Something to point out is that by the age of 10, research demonstrates that by the age of 10, a child is no more suggestible than an adult. So that's an important thing to keep in mind given the age of many victims in these cases. Lastly, lawyers know the law of primacy and recency. Just psychologically, in any sort of presentation, the things that are most powerful are the things that occur at the beginning of a presentation and things that occur at the end of the presentation. So, for example, in this webinar, we had audio issues early on. That is likely to loom large in your memory of this event and how you assess this event, unfortunately. But lawyers know that, and so powerful stuff in cross-examinations is likely to come either early on or near the end as they seek to maximize the psychological effect for the jury. All right, we're going to skip over a hypothetical just so we can get to some more questions of yours at the end. I really appreciate the many questions that were submitted. A couple general testimony tips. When you're, many of you have seen the Snickers commercial, hence the public domain Snickers there. When you're angry, you tend to do things that are not particularly intelligent. And as Snickers says, you're not you when you're hungry. Likewise, you're not you when you're angry. And there's a couple of fun examples of that. I remember one of the first trials I had, or rather one of the first cases I had involving child sexual abuse material. It was a defendant who accessed horrific material on the dark web, very just gruesome, horrific images depicting child sexual abuse. And so he pled guilty, and as we're at sentencing, reading through just various things that he accessed on this site, things that he downloaded, how long, the hours and hours that he spent on this website. And so at a certain point, he jumps up, and he's angry just by many of the things that I said. And, of course, his attorney is telling him to sit down and shut up, but he's having none of it. And he says, "Your Honor, the prosecutor just perjured himself," which wasn't true. But the prosecutor just perjured himself. He says, "I spent hours and hours, staring at all these videos and images," he said. "But, Your Honor, I've got really slow internet. And when half the time I was just staring at the screen waiting for all this to load." Really unhelpful thing for him to say at a sentencing hearing. It didn't go well for him. When you're angry, you do dumb things. So don't be like the defendant in that case. As Lumiere and Mrs. Potts say in Beauty and the Beast, above all, you must control your temper. Don't get defensive. Don't take things personally. Oftentimes, that's a defense goal. The last time that we did forensic interviewer at trial course, often it's very therapeutic for me to play defense attorneys. And so I did a defense tactic where you just pick something that you're annoyed about in the case and you just rant and rave about it. And afterwards, the forensic interviewer asked, did I do something wrong? What can I do to avoid that line of questioning? Because you were just yelling and screaming and all this stuff on the stand. And I said, no, you didn't. There really wasn't a problem there. I just didn't, when defense attorneys don't like the questions you give, sometimes the response is to snarl and yell to throw you off. All right. Thinking before you speak is important. Listening carefully to the question, not just the tone of the question. So, for example, when I'm snarling like an angry defense attorney because the responses were not particularly helpful to the defense, the tone is intended to intimidate a witness or manipulate a witness. Listen to the question, not the tone of the question. Oftentimes, the attorneys are just looking for a reaction from you, and the answer to the question is irrelevant. Likewise, if you don't understand the question, simply ask to repeat and rephrase. I don't know is a fine question, or a fine response, rather, if it's true. Now, one of the things was just talking to some investigators yesterday about things they didn't like about testifying, and one of the things they pointed out was the lack of control, because the attorneys are really controlling the pace, well, rather not the pace, but they're controlling the flow of information, and so there's this general frustration that you can't take control of the process of testimony. And that's true, mostly, but you can take control of the pacing. Attorneys can't control how quickly you answer. You can't dictate it without looking rude. You can have some that maybe aren't very, that might try to interrupt and whatnot. That compromises them to some extent with the jury. A judge who's controlling the courtroom will intervene at that point. If the judge doesn't intervene, you can turn to the judge and say, that wasn't my complete answer. Would you like me to finish? So if you have an attorney, like for me personally, I like to control the flow of information. I want to keep my questions coming quickly, so the witness might be a little off balance, obviously depending on who I'm questioning. One thing that would throw me off is when a witness just took their time. And obviously you want to do that in a way that the jury doesn't feel it's wasting their time. But ultimately, attorneys can't really dictate pace. They can't make you answer fast or quickly. And so that's one thing to consider if you're being thrown off a bit. So a couple bolts for you, and again, I know some of this is fairly basic. Hopefully we'll get into things that are more helpful for those of you that have a bit more experience in this field. But of course not nodding, and that's easy to say, but I've actually done this. I'm a foster adoptive parent, and I have answered a question by nodding, and that was after I was a prosecutor, so I knew better, and I still did it. Not answering a question with a question, your temptation is often going to be to argue and throw something back in an attorney's face, but that's not helpful. Judges don't like it, juries don't like it, so that's something we want to avoid. Certainly avoiding guessing. We've got a great clip from my cousin Vinny near the end of this presentation that illustrates why guessing is a particularly bad idea for our credibility on the stand. Don't use jargon just within your field. So you don't want to be saying things like TSCBT, that would be trauma-focused cognitive behavioral therapy, and you want to explain what that is. Even more basic jargon and acronyms are often not going to be known to the jury. So Child Advocacy Center instead of CAC, multidisciplinary team, explaining what that is versus MDT, and so on, avoiding the jargon of our field. We don't want to, more often than not, we don't want to attempt humor. There is a correlation of a humorous atmosphere to not guilty verdicts. We certainly want the jury to take this seriously because it is serious. With that said, I have seen a couple times where humor has been used incredibly well, but for 99+% of people, I would strongly suggest avoiding humor in the courtroom. If you hit it out of the park, it'll be fantastic. If you don't, it could be disastrous. So I would not roll the dice on that. Obviously, we want to stop talking after an objection. We don't want to box ourselves in with absolute type statements. What do I mean by that? Don't say things like always or never or all or every. Those types of absolute statements are just begging for a line of cross-examination from an attorney to show all the many exceptions to always or never or all or every. Perhaps the answer is that, in which case the response is fine. But we generally want to be avoiding those types of absolute answers because they do leave room for a cross-examination. We shouldn't tell our significant others that they always do something, and likewise we shouldn't say always, never, etc. on the stand more often than not. You could say, I don't believe so. You could say, I don't remember, I don't recall, but we generally want to avoid those absolute statements. We don't want to counterpunch every time. So one thing that I think is helpful, defense attorneys do try to get you into a run of no, 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 yes, yes, yes. One way to break that up, as we'll talk about in a second, is pivoting. So we could say yes and go off on a tangent that's relevant. Yes, because, no, and this is why, and things like that. But we don't want to do that every time. At a certain point, it simply looks disingenuous, and it just looks argumentative, and it compromises our integrity and our partiality. A couple do's. We certainly want to speak to the court with respect, saying Your Honor, even if we might have issues. You know, one area where I've seen this be a challenge is with younger social workers who just saw some horrible ruling from a court that they felt, and frankly it did, really compromise the safety of children. And so you can see you can just see that disrespect just on their faces when they testify. And that's not helpful. It's not helpful to the case. So that's certainly something we should avoid. Always speak to the court with respect. It's something the juries certainly are going to expect. Being reasonable. We start, those of you who are not attorneys, you start with an advantage. Jurors tend to identify more with witnesses, not with lawyers. Witnesses are actual human beings. They're generally likable. Just be reasonable and keep them on your side. Something we want to review any document you're presented with carefully. If you haven't seen it prior to, then say so. Your temptation might be to rush and run through it really quickly because silence in the courtroom feels just very intense, and I understand that. But take your time and don't do anything that might compromise your position later. Picking the right battlefield, as John Steinbeck said, if you find yourself in a fair fight, your tactics suck. You don't want to get in legal arguments with a defense attorney. You want to stay in your field of expertise, let them swim in the deep end of your pool, and not vice versa. If your area of expertise is forensic interviewing protocols, that's where you want to be. If your area of expertise is investigations and how those should be conducted, that's where you want to be. Stay out of the law and stay in your area of expertise. And again, you can pick when there's appropriate points in the cross-examination, you can pivot back to your direct testimony if you're talking about areas in which you're comfortable. Again, you don't want to do that too much because at a certain point the jury might lose patience and feel you're wasting their time, but certainly at points that's certainly appropriate to pivot. Also, you can show unforced genuine emotion. This is another question I get a good bit. Oftentimes, I'll hear guilt expressed from an investigator or a therapist or someone else who was emotionally compromised on the stand. That's okay. And in fact, it's helpful often. It's powerful to see authentic emotion. And frankly, it adds credibility to the case because they see the genuine way.
Just wish we could all get along like we used to in middle school. I wish that I could bake a cake made out of rainbows and smiles and we'd all eat, be happy.
She doesn't even go here.
And again, the importance is for it to be.
Do you even go to this school?
And this next
No.
illustration.
I just have a lot of feelings.
Okay, go home.
All right, so let's talk a little bit about demeanor. Maya Angelou says that people will forget what you say, but people will never forget how you made them feel. So how does your tone and nonverbal make the jury feel? Jurors, like most people, filter facts through emotion. So does your facial expression look like you just got in a fight? If it's unpleasant, that's probably not best. Typically what we recommend in terms of courtroom demeanor is a subtle, composed smile. You want to look like you're in control. And don't react. Nothing surprises you, right? Even if it shocks you, nothing should surprise you. Nothing should undermine the case. And if it's not affecting you, what does that say to the jury? It says that whatever the defense attorney happens to be jumping out up and down about is not relevant. And another thing I would say that I found helpful just in testimony is you want to think of a person who you respect. As we talk about tone, you want to think of a person who you respect, that you enjoy talking to, that you're comfortable talking to. So for me, the person I would think of was Boz Javidjian. Some of you may know him, excellent sex crime prosecutor out of Florida. Now he was the executive director of GRACE, Scholarly Response to Abuse in the Christian Environment. Now he is a civil attorney assisting victims in civil claims. So when I would testify, he's who I would think of because I'm comfortable talking to him. I greatly respect him. I enjoy talking to him. That's the general tone that I would attempt, and so that might be something that would help you. Regardless of how angry the defense attorney may be, Allison Liotta, who's an author and a former federal prosecutor, she once told the American Bar Association that in terms of toning the courtroom, kill them with kindness. You're nice to a court reporter. You thank the bailiff. You thank the clerk. You're nice even to the defense attorney. You bless, sneezes. That has an effect, as does clothing, professional clothing, conservative clothing. We know that's something that is expected in many of our juries. Speaking of jury expectations, oftentimes juries have flawed beliefs on body language and on truth-telling. They might think, for example, eye contact. They might think that if you can make eye contact, you're telling the truth. But if you can't make eye contact, then that is indicating that you're being untruthful or deceptive in some way. But that's simply not the case. And think about who that favors. There's an inherent unfairness there when we talk about victim and perpetrator. A child or adult victim of sexual abuse is going to find it harder to make eye contact with a room full of strangers as they talk about intimate violations of their life and of their body. Whereas a perpetrator is used to deception. He's a practiced deceiver. He's very comfortable making eye contact and telling people absolute nonsense. And so naturally, that is going to favor perpetrators. Studies show that there's actually barely any difference between professionals' ability to determine truth from body language itself. It's about 50-50. Juries even more so. And so we know that those incorrect beliefs often play a role in their often misunderstood beliefs about body language in truth-telling. Remember, the audience isn't the attorney. The audience is the jury, unless you're in a bench trial, in which case the audience is the judge. So what I generally recommend, if there's a short answer, yes, no, etc., you can just direct that straight back to the attorney. But for longer answers, where it's a few sentences, something longer than a phrase, involve the jury. Turn and talk to the jury. You don't want to make that forced, but that's something that you want to walk through and discuss. One note on eye contact. Well, I'll get to that in just a second. Let's talk posture first. When it comes to posture, we certainly don't want to slouch. You do want to project openness and confidence and take up space without being arrogant. So you don't want to have your arms crossed so you're looking combative, but having your arms shoulder width apart is helpful. Taking up a bit of space, using your hands when you talk, those are all helpful just in demonstrating confidence. There's a great book out there by Cara Alter, C-A-R-A, Alter, A-L-T-E-R, called The Credibility Code. And she does a great job walking through nonverbal language and posture and things like that. I saw her do a keynote presentation. I believe it was in Minneapolis a year ago, and it was incredible. She would deliver the same line in the same tone, but change her posture or nonverbals, and it would have a totally different meaning in terms of her credibility. So I'd recommend that book, The Credibility Code. You can get it. It's not very expensive, just online. And what I like about that book is there are actually QR codes in the book that you can scan with your smartphone, and it'll take you to videos of Cara demonstrating those nonverbal techniques. So that is really helpful if you want to improve your skills on the stand. I would commend that to you. When it comes to eye contact, you might be tempted, especially if you're nervous in a courtroom, to fixate on one specific individual. And that's sort of your lifeline, especially if it's someone who's nodding and smiling and maintaining a connection with you. Some studies tend to indicate that's a bad idea, and just these are generally surveys of juries after the fact, and they said they felt really unnerved by that and that it was creepy that you just kept staring at them throughout the whole process. So a couple solutions. You can look at different individuals in the jury. Don't spend too much time on one individual. If you're the kind of individual that's really uncomfortable with eye contact,
I would be creeped out by it, but it's nothing
where it looks like
to the way
you're looking
Michael
at the jury,
looks
but
at
you're
me.
really not. So maybe right above the heads of the back row of the jury, or maybe right to the side of the last juror. So it looks like in the frame and the interviewer keeps pulling the hands down. So we want to avoid distracting mannerisms. Let's jump ahead to the next slide. All right, some of you had asked about common cross-examination traps. So this is by no means an exhaustive list, but it's just a few of the things I've seen, and certainly there are many more. We need to think about what a cross-examination boils down to. Ultimately, cross-examination boils down to control. The answer that an attorney wants, most of the time, not always, is a simple yes or no without explanation. So that's why pivoting can be very helpful. We don't want to simply be a yes man. Now, my caveat there is if it's a basic yes or no question, then answer it yes or no. You don't want to be overly combative or partisan. The jury sees that to be straightforward. But oftentimes, questions are not yes or no. Questions need explanation in order to be thorough and to be honest. So don't be a yes man, hence the photo of Jim Carrey. Make sure you give that added explanation when it's appropriate to give explanation. Incidentally, scientifically, people are more likely to agree to an argument or pitch if you get them to say yes first. This is why those attorneys sometimes open cross-examination with a series of concessions, get you to say yes, 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 yes a bunch in a row. Salesmen know this, right? They improve their sales if they can get you to say yes first, then begin the pitch. It creates sort of a sense of obligation. We're, most of us at least, are nice people. And so, and this is something we do on the criminal justice side of things. I'll tell investigators, flip a password request into your mundane questioning of suspects. Hey, what's your name? Where you live? What your kids go to school? Oh, where at? What's the password to your phone? What has been nice outside lately, right? Just those standard easy questions sort of set you at ease. And so you don't want to fall asleep at the wheel while you're on the stand and answer yes or fail to clarify during a string of yes questions. There's one criminal defense website I saw recently where the attorney said, and this is a direct quote to his fellow defense attorneys, push a submissive witness as far as you can. That loses cases when you allow that to occur. So certainly don't be a yes man. Likewise, don't answer a compound question without clarifying which part you're answering. So compound question meaning a double question. There's multiple questions within the same one. And so you want to clarify that. You want to address that and address which part of that question you're answering. If the attorney is making a statement instead of a question, which certainly happens sometimes, you can simply apologize, politely ask for the question. Sometimes we see an ambush by article. Sometimes you see an ambush by article. And at that point you can say, look, be honest, I haven't read every item in the literature. And that doesn't mean that it compromises your integrity. It just means that's simply not how it's done. I would. You can also impeach by prior. There's also impeachment by prior inconsistent statement, and this is where preparation and review is important to avoid. Review that prior statement to refresh recollection. If you testified at a preliminary hearing, you want to go back and review that preliminary hearing to make sure everything is consistent. And if you are really inconsistent, obviously your first duty is to be honest. If you really were inconsistent, state you were mistaken, if something has changed, or if your understanding of something has improved between past testimony or past statements, own that, explain it. Don't try to dance around it. If there truly is an issue, deal with it. All right. Answer both the question and the implication. So the last question, we oftentimes they're trying to get you to answer the question, but oftentimes there's an implication to the question as well. We'll have an example of that in a moment. Yes or no questions. If we were not in a virtual platform, we could have a nice interactive discussion about how you all handle that. I'm sure many of you have been in the situation where the attorney says, no, you need to answer yes or no. It's a yes or no question, again, so they can control the narrative. So don't let them do that. Some question. If it is a yes or no question, then answer yes or no. And there's a variety of counters you can make. Not necessarily if it's yes or no, and then give the explanation, it depends. Or no comment, it depends. Or I would need to know more. And then you can educate. That's a good response, incidentally, if they're asking you a hypothetical. So hypothetically, what about blah, 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 blah. So what you want to do is say, I would need to know more. You want to note that that's a hypothetical situation. Say you would need to know more, and then use that opportunity to educate the jury. Again, using those pivots, yes, no, and, yes, no, because, yes, no, but there's an important explanation. Or I don't know at times. And if the counsel pushes you, you can simply say, I'm sorry, counsel, I can't answer that question, yes or no. may I explain why? Almost certainly they'll say, let's move on, and they probably won't let you, but hopefully, again, you've developed that rapport with the prosecutor beforehand, and he'll come back on redirect. Again, you don't want to have a long string of no's, and sometimes that's the way some attorneys will conclude a cross-examination. Defense might make that one, might like to make you look bad, so that long chain of no's does look bad. So you can mix it up a little bit. You can say no because it's not best practice to do X, if they're alleging that you failed to do something you should have done. Did you read this obscure article? Well, no. But you can pivot to other knowledge bases. Or if it's a simple yes or no, just say it's no. Anytime you can number your responses is a good thing, if you can truly number your responses. Did you do X thing? No, counsel. There's 3 reasons why I didn't. Attempt to go into it. If the attorney cuts you off, that just makes him look like he's trying to hide information from the jury. What you want to avoid there, though, is the Rick Perry effect. Some of you may recall years ago in the political debate where he says there's 3 agencies of the federal government that I would eliminate on day one. It's 1 this, 2 this, and the 3rd one I can't remember the 3rd one, right? You want to avoid those types of situations, but if you can number it and deliver it, it looks pretty good anyway. On this yes-no issue, this is a judicial perspective for you. This was from the Honorable J. Thomas Martin. He was a senior U.S. District Court judge in the District of Kansas. And so this provides some clarity on how far a judge or when a judge will typically intervene. And so the judge here is asked if he has a rule on how many times he'll allow a witness to go beyond the yes-no answer, provided through its explanation, as I just said, where the question clearly asks for a yes-no answer. And this judge said they try to be fair. If counsel appears to be attempting to cut off a legitimate, non-argumentative answer, I will allow the witness to answer. If the witness has been difficult and appears to be trying to frustrate counsel who is asking simple questions in good faith, I'm inclined to restrict the witness. And while it is a horse out of the barn situation, I occasionally instruct the jury to disregard certain testimony and straight from the record. So that's a helpful judicial perspective to give you a bit of a sense of what the judge is thinking. All right, so we want to avoid other traps we might see or hypothetical questions, certainly. Again, acknowledge the question hypothetical, highlight the missing information. Again, watching where the attorney is leading you. For example, sex crime cases where family and friends want to talk about all the nice things the defendant did for the child. When I'm a prosecutor in those situations, I let them. If they want to talk about all the food that the defendant lovingly prepared for the child, or the gifts that the defendant showered on the child, or how often the defendant would offer to volunteer with the homework, or take the child places, I want them to talk about all those things. And not because I think it shows that the defendant's a wonderful person who can never have done these horrible crimes, but because it shows the grooming process. And it shows the trust that the defendant had. The defendant had that child's trust, and what did he do if he betrayed it to satisfy himself? So that plays into my case. So if an attorney seems really eager for you to continue on down a path of discussion, there might be a reason for that. And also look for the one question too many. And this is a mistake that attorneys often make. Look for the one question too many. And that's a great opportunity to seize on an issue. So, for example, there was a medical malpractice case where an obstetrician was alleged to have caused brain and nerve damage to a baby when he delivered the baby using forceps. The plaintiff alleged excessive force, and the delivery room nurse testified for the plaintiff, claiming that the doctor did use excessive force. And so the defense attorney then cross-examined. The nurse did a really good job up until the end when he asked one question too many. And so he asked whether the word excessive in excessive force is subjective. Because, without having the actual forceps in her hand, the nurse couldn't have known how much force the doctor used, so she couldn't have known whether that force was excessive. And so the nurse concedes that. Should have stopped there. But then the attorney dug his grave. He asked the one question too many. How can you possibly say, then, that Dr. Simon used excessive force in using the forceps to assist delivery? And the nurse replies, because he put his right foot up on the rail of the bed and leaned backwards as he was pulling on the baby's head. One question too many. Should have left it alone. Occasionally you might get those questions, and those are opportunities to jump jump on it. We will unfortunately skip over, since we don't want the platform to crash, certainly, the clip from My Cousin Vinny. But in My Cousin Vinny, this illustrated the importance of not guessing. And it's a great clip. If you haven't seen it, check it out. It's entertaining, fun movie. But it's actually a really good cross-examination by Joe Pesci, where he gets the witness to admit that he was guessing in the time frames. And he does that surrounding the time frame on how long it takes to cook grits, and not instant grits. But we will sadly skip over that. I want to take as many questions as possible just in our remaining time together. While you all are typing those in and the Intact team is grabbing those, there were several questions I wanted to address that were submitted in advance. And again, unfortunately, there were over 100 questions submitted, so we're certainly not going to get to very many of those, but I'd like to highlight a couple of those. One of the questions that was asked that I thought was important is, when there are possible credibility issues on the victim side of things, how does one overcome those? Well, I would say, what we often think of as weaknesses or credibility issues when it comes to victim behaviors are actually strengths, and they're really strengths of our case. So, for example, promiscuity, substance abuse, all these academic problems. A lot of times those are simply coping mechanisms that we expect to see when it comes to victims, especially victims of sexual abuse, but other forms of abuse as well. And so those behaviors themselves are corroborative of the fact that abuse occurred. Those are reasons why the jury should find the child credible, not a reason why the jury should find them incredible. And in fact, they might even corroborate the time frame of abuse. We can say, oh, look at all these terrible academic issues that this victim has suffered through. Well, in some cases, when you look back to when those occurred, you have a great corroborative time frame for when the perpetrator was actually assaulting that child. And so oftentimes those quote-unquote credibility issues are really strengths and corroborative strengths of the case. And there's much more that can be said about that, but I do want to go ahead and throw that out there. Additionally, I know we have a few attendees, I think, from West Virginia. One of the attendees from West Virginia had asked, how do you calm your nerves before testifying? And that's a tough one. That's important for kids as well as child protection professionals. And certainly there's a variety of sources we could go to. How do you prepare for any other sort of stressful event? If we're talking about child testimony, then we might look to parents or other supportive adults in the child's life and say, how do you prepare that child for, say, a visit to the doctor or a test or a sporting event, and follow those types of things. There's an interesting TED Talk by social psychologist Amy Cuddy called Your Body Language May Shape Who You Are. Your body language may shape who you are. And Amy Cuddy says that power posing or standing in a posture of confidence, even when we don't feel confident, can boost feelings of confidence and might have an impact on our chances for success. And so she talks about, superhero type stances in a mirror. And I know I've already lost my credibility on that since earlier when the webcam was functioning, you could probably see the Captain America shield in the background. But nonetheless, don't recommend that you do those power poses, superhero stances on the stand, but perhaps in a mirror beforehand might increase your confidence. Meditation can certainly be useful. If anyone has any particular suggestions, I can recommend some of the things that I found useful. Just feel free to reach out and email me. You have my email address on the screen there. I'd be happy to walk through that with you. Let's see. One thing I definitely want to answer that several of you have asked, there are a couple of related questions. I'll bundle them together. Why can our forensic interviews not be used in place of our testifying? And a related question from Wisconsin, if you're the social work or crime victims person, how concerned should you be with hearsay? The short answer is you should be concerned to some extent, but let's break this down a little bit. So in West Virginia and in many other jurisdictions, and I would even say most jurisdictions, if it's a civil case, that forensic interview should really be admissible. So, for example, in West Virginia, where I practice Rule 8A of the West Virginia Rules of a Procedure for Abuse and Neglect cases, said there's a rebuttable presumption that the child's testimony is the necessity of the child's testimony is outweighed by the psychological harm to that child. And so if there's an alternative mechanism for that child's testimony, such as a forensic interview, that really should be the way to go forward. So the civil side, really that forensic interview should be getting in regardless. On the criminal side, if the child is not testifying at trial, there are two hurdles, the two reasons why that forensic interview might not be getting in place of your testimony. The first of those is the hearsay hurdle, and the second of those is the confrontation clause hurdle, which was really imposed post-Crawford. And there are whole thrilling lectures that I'm sure you all will be fascinated in hearing about the ins and outs of hearsay law. But generally speaking, certainly, so going back to West Virginia and on the criminal side of things, it really depended on our judges. There's many reasons why forensic interviews should be admitted and why they should pass both the hearsay threshold and the confrontation clause threshold. So, for example, West Virginia, like most jurisdictions, has what's called the residual hearsay exception, and that means where there are guarantees of trustworthiness, and we can demonstrate those through the statement itself, then that statement should be admitted, even if it is a hearsay statement. Hearsay meaning a statement that the child made not in the courtroom. There's this important Supreme Court case on that, Idaho v. Wright, that walks through what those various factors are in terms of assessing reliability and trustworthiness of a statement. And there are a variety of other hearsay exceptions. One that's really common is the hearsay exception for medical treatment. Arguably, portions of forensic interviews meet several exceptions to hearsay. The excited utterance exception, present sense impressions oftentimes. If a child who spontaneously begins masturbating, for example, in a forensic interview room, that's not hearsay. That's not a statement for the truth of the matter asserted. That's something that the forensic interviewer directly observed, right? So there are a variety of ways to get past that first threshold, the hearsay threshold. If a child witnesses testimony, if they do testify, if a child's witness's testimony is attacked on cross, the forensic interview often is admissible as a prior statement to rebut those specific defense attacks. So that's the hearsay side of things. On the confrontation clause side of things, that says the defendant has to have this opportunity to cross-examine and confront the accuser, even that is not absolute. So, for example, Ohio v. Clark, an important Supreme Court case in 2015, says that the confrontation clause will rarely, if ever, be implicated for younger children. And so that's something to keep in mind as well. So that's a long-winded answer with a couple detours, but there are a lot of ways that forensic interviews can be admitted. I think I know often prosecutors underestimate how often they might be successful. A lot of times they assume they can admit it, and so it doesn't wind up getting admitted. But there are a lot of paths to admissibility. That's something myself and others at Zero Abuse Project would be happy to assist any prosecutor on in thinking through the restraints of local law and how we can work on that. Some jurisdictions it's certainly more difficult than others. South Carolina is a more difficult jurisdiction, certainly than West Virginia, but oftentimes there are certainly paths to admissibility. All right, with that, let me open it up to some of our questions today, and I do want to get back to those broader questions. So if anyone has questions, I definitely want to follow up with any of you after the fact via email. Happy to have phone calls as well to address all these important issues. I see Alyssa asked, do you feel expert testimony on trauma and victim behaviors is helpful enough to sway a jury? Or rather, Alyssa is conveying this question. And if so, what tends to be most impactful? Well, yes, is the short answer. Certainly, expert testimony is critical to explain what the effects of trauma are and how victims often respond to trauma. It's very critical. You know, every piece of a child abuse prosecution has to be victim-centric. It has to be, or you're putting that child in an unfair position. So before a child even takes the stand, what I would typically do, and not always, obviously tactics vary based on the case, but what I would often do beforehand is put on a psychologist, maybe the psychologist who rendered a PTSD diagnosis, who could explain a little bit and contextualize victim behaviors. Maybe that's a discussion to have on the stand with the therapist or a parent. You definitely want to contextualize the child before putting them on the stand. You don't want to commit them to any specific behaviors because we don't know how children will respond in a specific way to various questions. But certainly expert testimony is a critical way to do so, and the most important thing we can do is contextualize that child and put them in the most favorable position we possibly can on the stand. All right, and I am seeing my time is up. William, do I have anything additionally, or is that the end?
That's it, and what I can do, Robert, is go ahead and wrap us up for today's presentation and allow for folks who did submit questions, we can get back to them, or also be sure to have them reach out to you. We have the Robert's information up on this slide, so if anyone would like to reach Robert directly or even reach out to Zero Abuse, you can do so as well. But thank you, Robert, for a great presentation, and thank you for providing the information for today's webinar. To our audience members, apologies for some of the audio issues that we've had, but what we will make sure is that we get the video and recording for today's webinar up on our YouTube page in 24 hours versus 72 hours, just so we can have folks to go back and review this information at a later time. And so before we wrap up, just wanted to, again, thank our presenters. Thank you, Robert, for a great presentation. For our audience members, if you'd like to get in contact with INTAC, you may do so through the links here. You can sign up for our listserv, where we can easily get you access or reminders for trainings like this that are coming up, and also go to Facebook to like us and check us out on any resources that we may have there as well. OJJDP TTA is our location there on Facebook. Would you like to get in contact with the help desk? Well, if you'd like to, you can do so through the information on this slide. You could also sign up for the OJJDP Just listserv as well. Click on the link here, and then you can go ahead and sign up with them as well to get access to upcoming webinars and other important information as well. Do you have a training or technical assistance need? Well, if so, please go to the TTA 360 platform and be sure to fill out a TTA request where we can get you linked to individuals to help assist with any of your training or technical assistance need. You can click on the link here, and it will take you to the TTA 360 site. Please note that, again, we will have this webinar up on YouTube in about 24 hours because of a couple of the audio issues that we had. But nonetheless, if you'd like to get any supporting materials for this or any past webinars that we've done with INTAC, you can be sure to do so through by contacting the TTA Help Desk, OJJDP TTA Help Desk as well. Please take a moment to review the attribution and disclaimer slide here, and I'll give folks just a second just to review this information here. And finally, we have a few other Zero Abuse Project webinars coming up that we're hosting through INTAC. We have one coming up next week, actually, on the 1st, and we have another coming up on the 13th as well. Please be sure to register for those webinars. They are live, and you're able to register for them. And then we also have a couple of webinars for our colleagues with WRCAC for their trauma-informed care series that are coming up later in the month. So please be sure to register for these webinars as well. And finally, we have a quick exit poll for everyone here, and we want to know, how do you plan to apply the information from this webinar in your work? You can simply click on the option that is next to your option there, and please note that you can select multiple options here, so don't feel like you have to only select one. You can select multiple options that we have here that will allow for you to let us know how you plan to use this work. I'm going to keep
Please hold while I confirm your passcode. Thank you. Your passcode is confirmed. Everyone will hear music until the host joins the meeting. To prevent sending any background noise into the meeting, mute your line by pressing *6. To unmute your